Yes, good morning.
My name is Sakok, Court Assistant. Anti-corruption case number, miscellaneous application case number E022 of 2020. Then is Itumbi versus Dr. Fred Okemba Matiangi.
Good morning, Your Honor.
Yes, good morning.
Yes.
Yes?
If you agreed to us last week to just speak and introduce ourselves, is still extended. Mr. Mungina,
Just wait. Mr.
Mongela is present for the interested party. My learned senior, Ms. Kahoro, and myself, Mr. Owiti, present for the second respondent.
Mr. Witty and
Kahoro, Penny Kahoro.
Your Honor. Filed an application which have applied for your refusal on this matter.
Mr. Itumbi, sit down. When a matter is fixed for ruling or judgment, what comes first?
Well,
Let me read my ruling, then you can make your application.
Your Honor, my presentation was that once your ruling, in the event that your ruling finds against my application.
Are you preempting the ruling?
No, I am not preempting the ruling, Your Honor. I'm only saying
Okay.
that the court is defunct as official.
Mr.
At that point,
Mr.
I just want to get on record.
No. There are procedures in courts of law. When a matter is fixed for plea, it comes for plea. When it's come for ruling, it comes for ruling. When it's for judgment, it's for judgment. The procedure demands that there is one step after the other. Unless you have different law to guide the court on that,
No, Your Honor. I just wanted to put on record and put an application this morning. And that application has an impact on the ruling you're about to make. It is only therefore fair, Your Honor, that you grant.
my ruling is ready. Listen to the ruling and then make your application.
At the point when you
That is the procedure I have practiced for the last 25 years. Mr. Itumbi, sit down. Please. Mr. Itumbi, sit down, please.
Much obliged, Your Honor.
Yes. This is the ruling that was fixed for today. Yeah, forget about that. It happens. Now, the applicant Dennis Itumbi, by way of a certificate of urgency, accompanied by a notice of motion and an affidavit sworn by himself, all dated 18th of November 2020, moved the court for the following orders: that this application be certified as urgent and service be dispensed with, that the applicant acting in person be granted permission to conduct the intended private prosecution. that this Honorable Court be pleased to issue summons compelling the attendance of the first respondent accused person named herein to appear before this court, this Honorable Court, on a date specified in those summons to enable the Honorable Court deal with the charges. That this Honorable Court be pleased to make any other orders it deems fit. Anti-corruption courts draw their authority from Section 4 of ASECA, which also provides guidelines for trial. I have informed myself on all the provisions of the said Act and have satisfied myself that I have the necessary jurisdiction to hear and determine this application. The application, which was filed on 23rd November 2020, was based on 22 grounds. As I was required to do, I set the ex parte application for hearing on the 24th day of November 2020. The applicant was accorded a chance and was heard on whether his application had met the necessary threshold of enabling the court issue summons compelling the first respondent to attend court on a given day. While arguing his application, the applicant described himself as an experienced investigative journalist who has worked with local media houses and as an international correspondent who has also published his own county newspapers. In his affidavit, the applicant gave a chronology of events culminating to his application before court. He also relied on the cases of floriculture and 4 others versus AG Nairobi, miscellaneous application number 114 of 1997, R versus Chief Magistrate and 4 others, and Moses Agumba 2016 EKLR, and submitted that there was a clear procedure. Further, that he informed the investigators via a letter dated 8th October 2020, marked D146 and D147 to the interested party, and a response to which he replied by D148, that the second respondent by D146 said they will update the applicant in due course. The applicant informed the court that he obtained the documents particularized in his affidavit from public officers pursuant to Article 35 of the Constitution on access to information, that he did not make any request for the information but used Article 34 of the Constitution on the freedom of the media. While being referred to Sections 80 and 81 of the Evidence Act, Cap 80, he informed the court that this being a special prosecution, being a layman, and having been frustrated by investigating agencies like the interested party and the second respondent, he did not pay for the documents. He concluded by seeking for an order to file witness statements. The court took notice of representatives of the second respondent in court and made necessary directions. His affidavit had a total of 82 paragraphs and 50 annexures, marked from D1-1 to D150. He drew the proposed 4 charges against the first respondent, 3 of which were brought under the Anti-Corruption and Economic Crimes Act, 2003, otherwise called ASECA, and 1 under the Penal Code, Cap 65, Laws of Kenya. In determining this application, the court informed itself of the previous decisions by superior courts by which it's bound. They are Isaac Aluoch Polo Aluchier versus Kalonzo Musyoka and 218 others, 2013 EKLR, Floriculture International Limited and others versus R, High Court Miscellaneous Application number 114, think there was a repetition, cited with approval, that is Floriculture International Limited and others versus R, cited with approval in Otieno Clifford Richard versus Republic High Court Nairobi Miscellaneous Civil Suit number 720 of 2015, R versus CM's Court Milimani and DPP and three other interested parties. That was a JR Miscellaneous Civil Application number 622 of 2018. Having done that and having been guided by the said decisions and the law, the first issue for determination is whether the applicant within 30 days of instituting these proceedings notified the second respondent. At paragraph 70 of his affidavit, the applicant informed the court that he wrote a letter dated 5th October 2020 to the second respondent and the interested party inquiring about the investigations and eventual prosecution. He annexed a copy of the said letter marked D146. That by a letter marked D147, the interested party gave him an unsatisfactory answer, and the applicant went ahead to issue a notice dated 14th October 2020, that is D48, informing them that he was not satisfied and would pursue legal remedies available to him. He did not indicate the legal remedies. I perused the documents mentioned in the above paragraph are noted as follows. In D146 and D148, the applicant wrote the said letters as the Hustler Nation spokesman. I find that both documents fall within 30 days of filing these proceedings. The next point for determination is whether the second respondent, without reasonable cause, declined to institute the impugned proceedings. In paragraph 68 of the affidavit, the applicant indicated that sometime in 2018, the second respondent, upon receipt of the investigations file from the interested party, returned the file 3 times, recommending that the interested party must include officers from the Director of Criminal Investigation Land Fraud Department into the investigation in order to have a watertight case against the culprits to be charged. At paragraph 74 of the same affidavit, the applicant informed the court that by virtue of the constitutional mandate of the interested party, despite at paragraph 73 that the second respondent did not respond to issues raised in the letter, also informed the court that the interested party had no reasonable cause why it had not concluded the investigations to the loss of public funds. There is nothing in the affidavit demonstrating that the second respondent actually refused to prosecute. Returning a file for further investigations does not amount to a denial to prosecute. The next issue is whether evidence by way of an affidavit in this application meets both the constitutional and legal threshold in order to enable the court grant permission to initiate a private prosecution. The affidavit introduced both public and private documents. None of the paragraphs indicated the sources of information. When a litigant relies on evidence by way of an affidavit, that litigant must disclose the sources of information. While arguing his application, the applicant informed the court that he obtained the said evidence pursuant to Article 34 and 35 of the Constitution. For purposes of these proceedings, the relevant article is Article 35, which states, as quoted here under Article 35(1), every citizen has the right of access to A, information held by the state, B, information held by any other person, and required for the exercise of any right or fundamental freedom. Access to information is a right bestowed upon each and every citizen. This right, like any other right, must be exercised by the citizen seeking the same. The applicant did not demonstrate how he exercised his right under Article 35 that led to laying his hands on the information he seeks to rely on. Did he send a request, or did he just walk into the offices and obtain the documentary evidence? If so, from whom? The applicant did not explain how he accessed the information. The documents in his affidavit have the names of the makers. However, his affidavit does not contain any information as to whether he had the permission of the makers to use the said documents. Such information, in order to be relied on by the court in a criminal process, ought to be accompanied by witness statements by the makers or such other person who had such custody as and when the applicant obtained them. By not demonstrating how he obtained the evidence he intends to rely on, such evidence is amenable and susceptible to Article 54 of the Constitution, which states as follows. Evidence obtained in a manner that violates any right or fundamental freedom in the Bill of Rights shall be excluded if the admission of such evidence would render the trial unfair trial, or would otherwise be detrimental to the administration of justice. He ought to have explained how he obtained each and every piece of evidence in his affidavit. As indicated above, the applicant introduced both public and private documents. Among the documents were letters written by public bodies, among others, the Ministry of Education, the National Treasury, the Commission of Lands, Director of Survey, etc. The legal threshold of such evidence is found between Section 79 to 81 of the Evidence Act, Cap. 80 laws of Kenya, which inter alia states as follows. The following documents are public documents. A, documents forming the acts of the state. A2, of documents forming the act of the state of official bodies. And B, public records kept in Kenya of private documents. Section 81, every public officer having the custody of a public document which any person has a right to inspect shall give the person on demand a copy of it on payment of legal fees, therefore, together with a certificate written at the foot of such copy that it's a true copy of such document or part thereof, as the case may be. And such certificate shall be dated and subscribed by such officer with his name and title, and shall be sealed whenever such officer is authorized to make a seal, and such copies so certified shall be called certified copies. Section 81, certified copies of public documents may be introduced in proof of the contents of the documents or parts of the documents of which they purport to be copies. The applicant relied on his exhibits D1 to D43 that fall in the category of both Section 79(1), A2, and B above, while the others were generated by the applicant. Guided by the above provisions of the law, the court noted as follows. There was no demonstration of any demand to the custodians of the public documents. There was no proof of payment of the required legal fees. There was no certificate written at the foot of the said documents demonstrating that they were true copies of the originals. Neither were they signed or dated and subscribed by such officer with his name and title. Hence, Section 81 comes into play. The said documents as they are not certified as required and hence cannot be produced in court as proof of the contents of the documents that they purport to be. The understanding of the court is that besides the affidavit being defective, the exhibits attached thereto do not meet the admissibility test as provided in the Evidence Act, Cap. 80 laws of Kenya. D35, D37, D39, and D42 are letters from the Ministry of Education, whereat the first respondent was the Cabinet Secretary. The court perused and noted their contents. None of the said letters was authored by the first respondent. In criminal proceedings, the doctrine of vicarious liability does not apply. According to the Black's Law Dictionary, 10th edition, vicarious liability is liability that a supervisory party, such as an employer, bears the actionable conduct of a subordinate, based on the relationship between the two parties. This applies only in torts and not in criminal proceedings. In criminal process, the party accused of either committing or omitting to do the act complained of is the one liable. At paragraph 7 of the affidavit, the applicant quoted paragraph 176 of the judgment / finding of the High Court in the case of National Commission versus Afrison Export Import Limited and others, 2019 EKLR. That paragraph reads as follows, and I quote: had the applicant conducted an inquiry in accordance with the law, that means the applicant in the case I have quoted, had the applicant conducted an inquiry in accordance with the law, it would have been discovered that the land which was to be acquired for the two schools had already been surrendered and set aside for public purposes. We therefore find that the compulsory acquisition of the land on which the two schools sit did not meet the threshold of public purpose and should not have been undertaken in the first place. One cannot purport to compulsorily acquire what is already public land. It is the applicant which started off the acquisition process on a complaint based on historical injustice, which was then turned into a compulsory acquisition. Despite the sixth accused party insisting on due diligence being followed, the applicant did not do this. Instead, the applicant misled the Ministry of Education into undertaking a compulsory acquisition exercise that was totally unnecessary and led to loss of public funds, end of quote. The applicant, instead of quoting that paragraph in the manner in which it was pronounced by the High Court, he decided to perjure himself on oath by stating only the undersigned part of the above paragraph. This court finds that further to what the court observed above, by the applicant trying to mislead the court, the case alluded to absolved the officials of the Ministry of Education. And the Holy Bible guides that, be honest and God will reward you. Lastly, having said as above, and due to the other findings herein above, the court finds that the applicant's application dated 18th November 2020 failed to meet both the constitutional and legal threshold that would give this court the necessary authority to grant permission to the applicant in order to enable him to initiate private prosecution proceedings against the first respondent. The upshot of the matter is that the said application stands dismissed.
Point of Your Honor, I wish to request for certified copies of the proceedings, and may the record reflect that I filed an application before you.
Although we were not parties to the ex parte hearing.
Just a moment. Reflect that I made a An application before the ruling, eh? Mr. Whitty?
Similarly, although we were not part of the expert hearing, we'll be asking for a copy of the ruling for our records. A similar application is made for the interested party.
Yes, Mr. Itumbi, your application is allowed subject to payment of legal fees required. Yes, thank you. Call the next one.
Anti-corruption case number E036 of 2020. John Amburu Mwangi.
Note the ruling of the magistrate of the anti-corruption court, the chief magistrate of the anti-corruption court. However, I wish to say it's not over yet. I will be proceeding to the High Court for a revision of that ruling by the magistrate. I feel the magistrate applied himself unfairly, and that was the application that I filed yesterday and was received by the registrar of the court. I wanted the magistrate to recuse or withdraw from this matter, given the judiciary code of conduct, and I've shared that document with you. It has the relevant authorities that a judicial officer who claims on record that facts do not matter, then should never sit into a matter because bias is inferenced. If you read the ruling that he has made today, he seems to be already arguing the matter substantively without listening to the parties. I think it is time for the judiciary to address itself to the issue of private prosecutions at length. We are happy that today every household in Kenya knows there is a relief known as private prosecution. We will therefore not be the ones who betray the cause of us achieving what is offered by the law on private prosecutions. We will therefore ensure that we go to the highest possible level to ensure that we get the relief that is necessary for private prosecution. There is absolutely no doubt from a ruling by the High Court that has been quoted by this magistrate that CS Matiangi sought for a quality and standards report from his own ministry, which he ignored. Therefore, the issue that he was misled is moot. He was advised by his own ministry officials and civil servants that he should not buy public land. Article 107.1 puts the responsibility of purchase and compulsory acquisition of land right on the foot of CS Matiangi. Therefore, it does not matter whatever method that they use, whatever bias that is inherent, that so to achieve or to defeat justice, we will ensure that we go to the highest court in the land to ensure that justice is served. Thank you very much. The purpose of the application was for the magistrate to recuse. The provisions of the law are that at any point a prosecutor can move to court and withdraw and file an application for recusal of a judge or a magistrate for that matter. But in the event that I raised the matter before he made the ruling, but he seemed to be saying that he would rather first of all dispense with the ruling because he knew what he was going to do. He was going to declare the court functioned as official, and I raised that issue so that then I am not able to file anything else that can be heard before that. The application seeks for him to withdraw from the matter and the matter be allocated to someone else because of what I believe was inherent bias during his first hearing. He claimed that facts do not matter. We all know that affidavits, by their very definition, is statement of facts. Therefore, a magistrate sitting to rule on a matter cannot say facts do not matter. Facts do matter, and they are the heart of any judiciary petition.
How soon will you be moving to the High Court?
I'll be moving for revision of the High Court immediately. I'm going to be sitting down with my research team, and we are going to compile whatever is necessary to come back to court, and you, ladies and gentlemen, will be informed once that is done.
Asante sana.
Thank you.